Hi, I'm Michael Carlin from Signature Premier Properties. Today, I wanted to bring something of great value to my clients. Information regarding estate planning. It's something that we all need to know for our family, even if it's about a subject that we're not all comfortable with. I learned about this last year when I lost my father, and I didn't realize how much there is to know. With that being said, I want to introduce John Zenir.
Thank you, Michael. Yeah, I'm an attorney. I do estate planning, as you know, Michael, and I was a litigator for 30 years doing family court and divorce cases. And over the years, my clients came back to me and asked me about estate planning, so I learned that. And I discovered a tremendous amount about estate planning in that people don't do it. Right now, 60% of people who are over 65 don't even have a will. They have no idea, and I think it's because of fear. People don't put together an estate plan because they're afraid of the future. Some may be afraid of talking to a lawyer because the lawyer may be using words that they don't understand. You know, that's the first thing I tell everybody. Any lawyer that you use to do anything, if they cannot talk your language, that's not the lawyer for you. You have to look for a lawyer who will speak to you in your language. You'll be able to learn and ask questions from it. So I got into estate planning, and I discovered that the biggest problem that people make is they don't fashion their documents to stay away from probate. I have a website called stayawayfromprobate.com, and that's what we exclusively do, is we try to educate people about how to stay away from probate. And it can be done. It's not a process that one size fits all, because every individual, every legacy, every asset that people have is different, and it's impossible to say, well, just use this form and you'll be okay. Like you mentioned with your own situation with your dad, the things you had to go through, and now some other things that you're looking to do. There's so many twists and turns that you have to consider, you know. So having a conversation that's a mile deep and a mile wide with an attorney is extremely important to do. You know?
Absolutely. It was a real eye-opener for sure. There are some questions I'm sure you're the man to answer. All right, so one of the questions that I had, what happens if someone dies with no will?
Well, if there's no will, then what has to happen for a home, for example, you have no other choice but to go into probate court. Okay, you have to hire a lawyer, you have to pay a fee based upon the value of the assets, and you also have to pay additional fees to the probate court. And keep in mind, as soon as you go into probate, according to the law, it has to take at least 18 months. You have to give an opportunity for any creditors to come in and file a claim against the property. So it's a very time-consuming and expensive thing, and two major things happen. Number one, surrogates court, which is probate and also other things that go into that court, but it's all about taking care of the assets that a decedent had. And there's two basic reasons when they put a house in such a way. They do something that used to only be, when I was a kid, it was only for rich folks. Now it's for everybody. You must put your house in a trust. And there are many, many different kinds of trusts. So people who have a second marriage with two different sets of kids, people who have a disabled child, or their kids are doing great and they want to put a trust together to help the grandchildren because the kids don't need anything. There's a million different ways to fashion a trust based upon the individual facts and circumstances. So number one, with the house in a trust, it doesn't go into probate. So you don't have to worry about many things. One of those things that you don't have to worry about is the step up in basis. That's a legal term, a property term. But what it means, when I bought my house for $44,900 in 1977, that sucker is now worth $783,000.
Yeah.
If it's not in a trust, my heirs have to pay a step-up gains on the increase in value. If the house is in a trust, it doesn't go to probate, and the people who now become the new trustees, my heirs, now get to step up to today's value, and there's no tax involved. Number two, the other thing that's very important, surrogates court is a public court. The documents there are not shielded from the public. So I could go online, anybody could go online and look at any surrogate's court in any county in New York State, click on a file, and just read through the documents. So you can find out, what houses may be for sale in the future. Many people do that as a way of developing property for sale down the road. So it's not public, you don't have to worry. And then the other thing that you don't have to be concerned about is you, as the person who has put your assets, your house and other things into the trust, you can now say to your heirs within that trust agreement exactly what you want to happen upon your death. Okay, so you can help avoid the arguments that occur between brothers and sisters, a nephew or a niece.
That's interesting.
Yeah, oh, it happens all the time. I have a situation right now, we're putting together an estate plan. I've encountered this time and time again. 2 kids, one kid lives in Cleveland, the other kid lives with mom and dad. The kid who lives with mom and dad has provided care for mom and dad for years, and they think they should get the majority of what's out there. It's a natural thing. Whereas the person out in Cleveland, the sister or brother, says, no, mom and dad, I'm sure, wanted to give it equally to both of us, because everything they ever did, they gave 50% and 50%. Right. They never favored you or favored me, and I know that's how they want it. So automatically, by not putting things in the appropriate manner that you will follow how the legacy is distributed, you eliminate all of those problems and headaches.
So not only are you protecting your property, but you're also protecting your family from having disputes over it.
Oh, yeah. Okay.
So that's very important too.
It certainly is. Awful lot of people have argument after argument. The plan that I was putting together, where I was in the house with the parents and the one child who was taking care of them, and that child is pretty adamant. They think they should get the overwhelming majority of the assets.
Right.
It's not unusual for that to happen. But the parents can now go ahead and put in exactly how they want these assets distributed. Okay? It doesn't have to be distributed immediately. It can be distributed over time. Some people will go ahead and they'll appoint the trustee who has to talk to their financial planner on a regular basis and keep the asset in the trust, and the trust may indicate that it'll be distributed over the course of years. It's not unusual. I think about, if I was to get $250,000 when I was 25, it would be gone mighty quick. But if I got it when I was 55, I probably would have invested a sizable amount in it to make it grow.
Right.
Well, you as the person leaving those assets to the kids can make those decisions and give the money out to the people that your loved ones, your family, give it out to them over a period of years. And it's just a nice feeling for parents. Once this is all done and the package is put together, almost everybody breathes a sigh of relief, because they figure
such a smart thing to do and invest in.
You gain clarity for yourself, clarity for your kids. They know what the future is going to bring, and it's a wonderful thing to have that situation.
Right. The last thing parents want is for their children to be torn apart by money.
A simple thing, forgetting the trust and the property for a moment, but parents can actually predetermine in their trust and in their other documents exactly how they want their funeral to go. So they can go to a funeral parlor. New York State has a wonderful program where you can prepay your funeral. Okay, pick out the casket, tell them how many limousines you want, if any, tell them how many days the wake is going to be, and this way your 3 kids don't go into the funeral parlor and have an argument about, well, $10,000 casket or $35,000.
Talk about white glove service.
It's a tremendous sense of relief, both for the parents and for the kids.
Certainly.
That these issues can be taken off the plate. They never have to get involved with it.
Right.
And it's just a nicer way to live, to plan. So funny. Today, parents have a 2-year-old kid, and what are they doing? They're looking around for the exact right pre-K school to go to. And they investigate, and they plan, and you name it, they do it. They make sure that the kids are signed up for dance and golf lessons. They're always preparing.
Right.
But when it comes to doing estate planning, for some strange reason, we just don't do it. And I think it's because of fear. Fear of the unknown, fear that you don't really have the skill set to understand
Right.
what's going on, because it is a technical area, needless to say. But if you have the right advisors, you're golden.
And then you have that relief you spoke about
That's right.
to know that
That's right.
you're all set.
Yeah.
So, very important.
Yeah.